Have you been sued for breach of contract in Texas? Or are you thinking about suing someone? If you're a business owner in Houston, here's what you need to know before stepping into a courtroom. So first of all, what is breach of contract? Promises between two parties, and breach is when one of the parties doesn't perform. And there are two different types of breaches. One is a material breach and one is a minor breach. You can really only sue for material breaches, not minor breaches, which is why the distinction is important. And businesses sue each other all the time over different things like missed payments and failed services and delivery delays. And here's the most important thing that I want you to get from this video. Commercial litigation is all about leverage. Commercial litigation is a tool. It's not the only tool. Sometimes self-help is a better tool. But litigation in a courtroom or hiring an attorney for a dispute can be a tool to get what you want, to get paid, or to extract even more money. You have to have a legal basis for it, but to extract more money from the other side. Maybe just to inflict some pain on another business or a competitor or a customer or employee, and just show them that you're going to enforce your rights. That makes a statement out there. But like everything with leverage, you only use leverage if it makes sense. You're not going to apply $1 million of leverage over a dollar dispute. So a lot of commercial litigation is in the very beginning, assessing what are we dealing with. So when a client calls me and they'll go into the facts, facts are great, background, whatever. I only need to listen to a certain amount of the facts and I've heard it all. I pretty much get the fact pattern. But my next thing is, okay, what are we dealing with? What's the damages for the plaintiff? What are the damages to you that we would be going after? The damages, again, are $10,000. Probably not going to hire me to go after someone for $10,000. You may even not want to spend your own time going to small claims court over $10,000. It may just not be worth it. Now, if it's $100,000 or $1 million, now we're talking. Now we have to judge, do we think we'll get a pretty successful result quickly by not expending much effort to go after $100,000? I don't know. We can start with a demand letter. We can send it, see if we can shake some money out of the tree, whatnot, and see if we get some money. If we have to file a lawsuit, if we have to go through discovery, if we have to go to trial, now we're spending tens and tens of thousands of dollars. We're getting close to that 100,000, and nothing's a guarantee. We may not get any recovery at all. So a lot of it, we just got to weigh the scales, and then there are trade-offs on how much we want to invest in this type of thing, and how much leverage that we have over the other side and how much leverage they have over us. And I'll discuss that next. So essentially, statute of limitations for breach of contract is 4 years. There can be oral contracts. I say that all the time to clients. They think that contracts have to be in writing. That's not true. Now, enforcing an oral contract, that can be more expensive because now it's a he said, she said. You have to have testimony on the stands, and I'm sure there's going to be different interpretations of what the contract actually said. So with that said, there are certain contracts that do have to be in writing. That's governed by the statute of frauds. And that's essentially like real estate contracts, some other things. We'll just say real estate contracts. You want to understand where your venue is. If your venue's here in Houston, where your company is located, that's your home field. You think you can plant jurisdiction here, someone's out of state, you have the leverage, because it's going to be a pain in the ass for them to hire a Houston attorney and come here in Houston, defend themselves, fly to Houston for a deposition, all that. It's good to be in your home territory, and sometimes that can have an effect on jury because you're the hometown company. On the other hand, if you signed a contract and Delaware law applies, and you have to come from Texas, fly out to Delaware, then you have to hire local counsel in Delaware. And guess what? A local counsel in Delaware is over $1,000 an hour. They're more expensive out there than they are here in Texas generally. Venue makes a difference, and you're the outside party as well, just like the flip side of what I discussed before. So if you're going to file a case, looking at venue is important. Also looking at whether there's mandatory alternative dispute resolutions. That's important too. There could be an arbitration provision You can try to invalidate the arbitration provision. We've successfully done that when we felt like being in court was really important for us. We didn't want the defendant to keep everything secret through arbitration, which is one of the main reasons that companies like arbitration provisions. So we wanted to file in court. We wanted it to be out in the open. We wanted the stigma of the public knowing about this. And guess what? When we actually defeated the arbitration provision, the defendant ended up settling after that because they didn't want to be in court. They didn't want it all to be public. So, one of the things that you should know is companies generally cannot represent themselves in Texas courts. Company can represent itself in small claims court, jurisdictional limits small and small claims court. But once you get into county, district court, a company can't represent itself. They have to use a lawyer. So if your company gets sued and you're in district court, if the amount of controversy is high enough, you have to call an attorney. You have to wait. And you have to hire one. And don't wait till the last day to respond. It's about 21 days to file an answer in Texas. An answer is not that scary in Texas. It's pretty much just a simple paragraph denial. The affirmative defenses get more complicated. And if you need to file a counterclaim, that gets more complicated too. And why would you file a counterclaim? Because you want leverage over the other side. If you're the defendant and you have any kind of counterclaim, it's mostly always in your best interest to bring a counterclaim against the other side. There's some exceptions to that, and you want to talk with a seasoned commercial litigation attorney that understands the nuances of all these things to determine what's worth it. Because again, what I want you to get out of this video is there are pros and cons. This is a business decision. You have to weigh both sides of the scale and determine how much of an investment and time and money is worth it, maybe, right? But we don't know exactly what's going to happen. But what's our best guess about the amount of pressure, the amount of leverage to apply to the situation to get the best result for the client? We've been doing commercial litigation for a while, and we've handled all kinds of different disputes for big companies and small companies alike, with a mix on the plaintiff side and the defendant side. If you want to talk to us about your commercial dispute in Houston or anywhere in Texas for that matter, feel free to reach out to us.